Only one of us can talk at once. I'm calling this meeting of the Board of Zoning Appeals to order. We do have one of our members is not here. I haven't heard anything. No? Okay. We'll proceed. Okay, the first item is calling the roll. I guess Michelle Summers is our zoning administrator, Jennifer Matthews, Alex Sharp, David Sonic, Ron Maxwell is not here, and Chris Bird is our representative to the planning commission.
And Jennifer is here. I didn't make any sense.
The first item is to adopt the meeting agenda with any changes, if any of the members have changes to suggest. Do you have?
I move it be adopted
As submitted.
A circulator.
Is there a second?
I'll second that.
All in favor?
Aye.
Aye.
Rolling now.
Okay, we have two sets of minutes that we have reviewed. Jennifer, did you have it?
No.
Do we have a motion to adopt those minutes?
There was one typo in the second one I saw. But I'll fix that. It said, it's a past tense of a verb. The ED wasn't on it.
Okay.
It said suggest instead of suggested or something.
Is there any others?
No, but I moved that they, and I made them change about half week last time. The June minutes, so I moved the June and July minutes be approved as amended.
Is there a second?
I'll second that with the typo fix that we've talked about.
All in favor?
Aye.
Aye.
Aye. Okay.
That was easy.
Okay, the next item on the agenda, and this states in implementation of, there was an attorney's general opinion that was rendered to us a couple of years ago for a very similar case. It related to who has the right to speak and be heard at an appeal of a zoning administrator's decision or ruling. And so I don't know if everybody is familiar with this. We got this.
Yeah, it was on the board
It's
doc.
on board docs, but I could, basically, the conclusion is that any aggrieved party or affected party would have the right to participate in the meeting. So it would be, I think the board concurs on this. It would not just be because you're a member of the county or even somewhere in the general area. It would actually be if you're affected, and certainly we have people who were mailed were mailed notice. I could certainly see where they would be affected. But
Mr. Chair, I'd like to read this. It's based on the clear intent of the code chapters of Virginia to afford notice to adjacent property owners who are most likely to be affected by the decision of the BZA, and based on the decisions of the Supreme Court with respect to variances and special exceptions, it's the opinion of the Attorney General that written notice to the adjacent property owners is required, which we have done, and that it provides that any person or persons jointly or severely aggrieved by the BZA may file a petition.
Severally. Severally, not severely.
Severally.
severely in some
And
cases.
severely so. The
Okay.
complainant must own or occupy real property within or close to the proximity of the property that's subject of the land.
So anyway, as the procedure goes, what we are considering is a fairly limited issue, which is the zoning administrator had rendered an opinion that this, and I'm sure everybody's familiar with the sign that we're talking about. She rendered an opinion that it was a sign and that it violated the ordinance. And I don't know that, I don't think that issue of whether or not it's in conformity with the sign ordinance, I don't think that's an issue. I think if it were a sign or is a sign, it's not in conformity with the ordinance. I think we probably concur on that. I think the question that Mr. Chapman brought up was, is this not a sign but a mural? And I think if that's the main issue, I think. So affected parties I'm not sure how it would be affected, but I think certainly neighbors, and that may be basically what we're talking about, would be affected parties. Now, of course, Mr. Chapman is putting on a case or making an argument through his attorney, Mike Brown. And so Mike can certainly call witnesses. I think that's the right, if you have anybody who, helps you with your case. So other than that, I think what we're looking at is somewhat limited, but if somebody really does want to speak, they could identify themselves, and then we could understand how they're directly affected. And if we think they are, then we would accommodate them speaking. Does that seem reasonable?
Yes.
Okay. So is it some discussion on this Attorney's General ruling?
Well, I just want to say that, that's a nice summary that you gave about the case tonight, but I think that we, number one, agreed, the board and the parties to the lawsuit agreed that when we got the Attorney General's opinion that we would make some changes accordingly, or not accordingly, depending on what the outcome was,
to our
procedures. That's not just going to apply to this particular proceeding tonight, but to all of them. And so I think that's what we should do. And next meeting I suggested that we take a look at what other jurisdictions have. And for example, Fauquier doesn't have really any specific procedure about that, or any statement about it. But Fairfax had something that I circulated, and I thought that was pretty good, which essentially says what the Attorney General's opinion says, that if you're potentially aggrieved party under that section of the code, which means you could appeal it to circuit court if you didn't like the decision, and that's a pretty limited group of people. Anyway, I think that is the rule that we haven't just adopt the rule they have in Fairfax.
Are you suggesting that, or are you making a motion?
Well, I'll make a motion to that effect, that we amend our rules of procedure to use that same language from the Fairfax procedure.
Well, I'd just like to make a comment. We've received documents from Alamo and Fauquier and Fairfax and several other places, but we've not, as a group, sat down and particularly talked about them. And so I'm not in favor of adopting something when we haven't had a chance to.
Well, this is our chance, so let's talk about it.
Do you want to read specific? Can you summarize specifically what this is?
Actually, I thought this would be I circulated it.
I'm hearing we're talking, the rules and procedures is the next item. So maybe we're drifting over into that.
Well, let me see what the rules say. You just had it.
I can
Well,
read.
right now, section, I think it's 2E, the one that governs appeals. And all it really says, it doesn't really say anything. It says the person who appeals will be heard, and the zoning administrator will be heard. And it really doesn't have, it says the views of the zoning administrator, that will be, the zoning administrator state his views of the case. Then it says recommendation of planning commission, if any. Well, that's really, these things don't go to the planning commission. So that should be stricken, subsection 5. And subsection 6 currently says, members of the public attending the public hearing shall be called upon to state their views of the case. Signed letters or petitions of residents or property owners shall also be considered. Any question they may have of the applicant, appellant, or witness shall be addressed to them through the BCA rather than directly. Unless permitted by the chair, no one other than BCA members may directly question an applicant, appellant, or supporting witness as well. everything but the last sentence, I think, has to be stricken because according to the Attorney General, and by the way, I'm not crazy about what he said in terms of limiting it to that, but we all agreed that we would do what he said. So what we have to do is substitute, well, it disappeared, but whatever's in that last paragraph, that it shouldn't be views of the general public, I think it should be views of aggrieved parties. And everywhere it says members of the public, it should say aggrieved parties pursuant to section 15.2, 23, 14, who, shall be called upon to state their views of the case and so forth. I mean, if you just substitute aggrieved parties for every word that says members of the public, I think you'd be okay.
Chris?
It seems we're in a situation here where we haven't really defined aggrieved to what. And the situation as I see it is that we are dealing with a situation in a village that has numerous businesses.
Wait a minute, we're not talking about this case, we're talking about the general rule.
Okay, well, I think that the general rules ought to at least apply to this case. And that as far as I'm concerned, the aggrieved could mean those who are negatively impacted by the situation, or those who are negatively impacted by a decision about the situation.
Or positively.
Or positively affected by it. And so what I would like to suggest is that people should be able to register their support, but basically that is registering support, and that those who are against it for their personal reasons should be allowed to testify or explain it, but it needs to be a real grievance.
Did you read this?
I did read that.
Well, it says, the last sentence says, an aggrieved person is one who owns or occupies
nearby property
It's
and
like stereo.
demonstrate a particularized harm or the imposition of a burden or obligation different from
So
the
that
suffered
would
of the
cover-
public in general.
Well, wait a minute, that's the key words at the end. Different from that suffered by the public generally. So people, whether it's this or, I mean, this opinion arose out of the Harmony Manor case. And in the Harmony Manor case, as distinguished from this one, the issue was about the use of the roadway, the private roadway that serves it. So everybody on the roadway was impacted by the decision. Clearly, because there was going to be more traffic or no traffic, depending on if the decision was upheld or not. So you have that kind of a situation. You could have a situation about, I don't say the height of a building, where something is permitted to be built that's in excess of, or some kind of variance. Well, then people are affected because if it's at a certain level, they won't see it, but if it's built higher, they will see it. And so every situation, I mean, I don't think that you can make a hard and fast rule other than that language, because every zoning, I mean, every kind of decision is a little bit different. You know, if the zoning administrator, for example, decides that such and such is a permitted use, and you're an adjoining landowner or you live 2 properties away, but somehow that use could contaminate the water table, well then that's, again, a different factor or a different situation than some of the others. When it's a situation like the one we have tonight, I mean, I think it's pretty limited to, I would have to say, people who are not only adjoining landowners, but who can see it from their property. And if they can't, then they're aggrieved. And if, I mean, whether they like it or not, they're potentially aggrieved, whichever way the decision goes. I would say that's, you know, the standard in a case like this. But just to, I mean, I have to say that, you know, throwing a thing open, this is a quasi-judicial decision that we have to make. And I mean, so it's kind of like court. You just don't let everybody who comes to court stand up and say what they think the judge ought to do. But you have to decide it on the law. And what people's opinions are is, no offense to anybody, but they're really kind of not really relevant. Whether they like it or they don't like it is also irrelevant. Whether we like it or don't like it is irrelevant in this kind of a case that we have tonight, because we can't regulate based on content. So whether it's beautiful or whether it's ugly, it just doesn't matter. The only question is, does it violate the size limitation? Because that's all she decided. She decided it's a sign, and she decided it violates the size limitation. And that's what the chairman said. I think there's much debate that it's over 75 square feet. So the question is it a sign or not? And I don't see how anybody, whether they live next door or they live 10 miles away, is aggrieved if we decide it is a sign or it isn't a sign. Well, the appellant obviously is. It's his sign or his mural or whatever it is.
Mr. Chairman, may I be allowed to address the board? I know that it's a bit out of order.
Yes, no, go ahead.
But because this is being debated on the same evening that my client's application is before the board, I would like to have a chance to address the issue. I think it's important for the board members to keep in mind what the letter from the Attorney General addressed. And the issue presented in the letter was not who may participate or who may speak in connection with an application on an appeal, but rather you have asked what public notice and what public participation, if any, are required for an appeal. And I'd encourage, Dr. Matthews already read it verbatim into the record, but I would encourage the board members to again look at the conclusion of the Attorney General hearing. And he's not saying that the board must limit those individuals who are permitted to speak in connection with an application. What he's saying is it's his opinion that the BZA must allow any affected person to participate in the hearing and allow any aggrieved party, and he uses two different terms there, any aggrieved party to address the BZA for a specified amount of time. That's provided in the code section. So I would submit to you that you're under no obligation to change the rules that you have already adopted this evening. It's perfectly permissible for you to allow anybody you want to allow to rise this evening and speak to you on this subject matter. What the Attorney General's opinion is about is that you afford a same amount of time to the zoning administrator when she presents her position to you, the time you allow to the appellant when we present our position to you, and anybody who can actually make out an argument that they're an aggrieved party, as it's defined in the opinion, they're supposed to have the same amount of allotted time. I mean, that's what this opinion stands for.
But the other people don't necessarily get in it. So we could say aggrieved parties, if the zoning administrator takes 20 minutes or 10 minutes, then you get at least that much, and any aggrieved party gets at least the same amount, and everybody else could be limited to 1 minute.
It is permissible,
yes.
Mr. Connick, I would agree, it is permissible for you to limit other comment to the extent that you feel necessary to limit, as long as it's consistent with the Attorney General's opinion. But I don't want it being stood on its head for the proposition that you must limit it beyond what's required here in the opinion.
Okay.
And you have a request that we allow.
You don't care. I'm already out of order in the sense that I'm participating in the board's debate over its own rules.
That's fine.
We let you, so you're not.
And I appreciate you affording me the opportunity to do that.
That is helpful, thank you.
Well, I mean, look, all I can say is when this first came up, Dr. Matthews took the position that nobody should be able to talk except the zoning administrator and the appellant. And I'm the one who contested it, and I'm the one who sought first I sought a court declaration of it, and we agreed to go with the Attorney General's opinion and compromise that way. And so it came out pretty much what I proposed. Anyway.
Sounds like you agree with mine.
So, but I agree with what, I think that's very reasonable, and I mean, it is a public hearing, and that was the part of it that never made sense. How can you have a public hearing, but it should be called a public listening then, not a public hearing? They can't talk, why should they come?
This does say that members of the public attending shall be called upon to state their views.
That's
That's a
What's in the current.
current, but
Okay, and
this
so-
says it supersedes that.
Let's say we're not requiring anybody to speak. Okay.
Except Mike Brown.
And what we would like to do, I'm speaking for everybody, I think, is limit the general conversation to relevant matters, and if we have to say how beautiful the sign is, we'll hear that as many times as we need to, but only once from each person. And otherwise, I guess, is that, so can we just have a consensus that we'll proceed in that way? That we will allow the aggrieved parties and anybody directly interested to have their fair share of time. We will.
I think there needs to be.
We will allow the public to speak, and I'm going to limit it as best I can so that it doesn't last all night and we're not repeating ourselves. Is that fair enough?
Yes, only the board should be allowed to do that.
And only Mr. Connor is allowed to repeat it. Okay. Okay, so that, I think. You tell us. Okay. Okay, so I think we've dealt with that. Thank you all for being so patient. The next item is the Cox and Davis tourist home. Is there someone here to, if you would come forward?
Picked a great night.
Yeah, you might say that. And if you would identify yourself and then just tell us a little bit about what you're doing, what you would like to do.
My name is Susan Cox Davis. Tyler Davis is my husband, and we would like to make our place vacation home a couple times a month for 2 people. And I've done all of the things that Michelle has said, and the VDOT and 2 parking places.
Where is it?
18 Water Street.
It's right on Water Street near
It's across from Riverside Auto.
Riverside.
So you get your car worked on.
Yeah, actually, we've done that already. Yeah, it's very
The
good.
guests.
Yeah, the guest center. Yeah, we advertise all of the local businesses in a little brochure. And one reason is when we first started coming here years ago, it was hard to find a place to stay. We thought, well, when we're not here, because we're here about every other weekend, and it would be a nice place for people to stay. And we're right in the village, walking distance from Applicant, and we really love it here. And we're going to retire here in 5 years.
And you're okay, you've established some fairly strict restrictions on how many times, like 2 or 3 times a
Yeah,
month?
just because we like to come here. And I would clean it in between the times that people came.
So that's satisfactory, you're not going to be coming back in 6 months wanting more? No.
Oh.
I mean, that's a couple times a month?
Yeah,
That's fine.
no,
Okay.
because I have to clean it.
And so you're willing to accept that as a restriction?
Mhm.
Okay.
And are you okay with it just being applicable to you so that once the permit, if you would sell the place, that the permit would automatically expire?
Oh, again, yes, that's fine. I didn't realize that was.
Well, that's something that we're
Yeah, I'm not,
going towards doing.
if everything goes right, I would retire in the place full-time
But
with
I
my
mean,
husband in 5 years.
if you, for some reason, move or sell it,
Yeah, we
do you have a
could take-
problem with that?
No, I don't.
That it would, that the, thing would terminate when
No, and then
you...
that person, if they wanted to do
They
it,
have to
that's
reapply.
that's fine.
Okay.
Yes.
And do you propose to have any signs?
No.
Just
We're all laughing for the wrong reason, but anyway, go ahead.
No, it has an address there. I think the only thing is to show exactly where the parking is. I might say parking here.
But the part, that's going to be not on the street or
No.
not visible from the street. And the reason I brought that up, folks, is because, just to clarify for all the laughers, is that unfortunately there's kind of a mistake in the zoning ordinance, and it says if you get a special use permit and the board doesn't impose some limit on signs, you automatically get the maximum that's allowed in an industrial district.
Which is 75.
It's 150
150.
So you
square
would
feet,
be welcome.
not 150 signs.
No sign.
150 1-square-foot signs.
Oh, yeah.
Just what I have stated in here. is
Okay.
location.
So we could add the limitation of a sign no bigger than 6 square feet or something? Because, I mean, you might want to identify the thing at some point by name.
I would think under the circumstances, the address, well displayed is,
Okay.
all the,
That's fine.
You don't want to put the Cox house or anything.
No,
What's your dog's name?
Phoebe.
Well, you didn't see the pictures of the little dog here and there and everywhere?
She's in everything.
Okay, you didn't bring the dog?
No, I didn't think she'd be allowed.
Okay.
You're right.
Okay,
We don't.
the planning commission, was there any?
The planning commission had no problem at all with this.
Have they established some requirements related to the building code?
They suggested
Yes.
that the safety requirements be adopted, carbon monoxide, smoke alarms, fire extinguishers,
Sheriff's number.
and emergency numbers, contact numbers, and that was agreed to by the applicant.
We have everything but the carbon monoxide. We're working on that.
It's an alarm, not carbon monoxide. right?
Alarm. Yeah, we don't want carbon monoxide in any place. We want an
Okay.
alarm.
Well, you both said that, so then I was trying to think, you have to have carbon monoxide.
And I think, I mean, we've had some discussion before about whether we need to be so specific about what the code requires or just state that it should be up to the code.
it needs to be specific.
You say it needs to be specific.
Yes.
Okay.
Michelle sent me a list. And I wrote
It
it
was-
down.
I mean,
Okay.
My history is the fire service.
So if the code changes, she's not required to,
My history is in the fire service. It's a 2A 10 DC wall-hung fire extinguisher that you should have on the premises for the people. Smoke detectors that conform to the current code, which in the situation on that house, no, I've been in that house also, which is,
and he's been in there.
but anyhow, in the hallways outside, but also in the room itself, in the bedroom.
Okay.
And I'm not sure, do you have a landline in that house?
No.
Because that,
Telephone?
yes, telephone. That can be a problem in Rappahannock County, in that people come here from elsewhere and they have cell phones and they expect them to work and they don't. And suddenly they have an emergency situation and they pick up their cell phone and they have no service. So I would ask that you
Does your cell phone work?
put in,
I have really good
What?
internet.
She
and-
said her cell phone works.
it doesn't make any difference whether her cell phone works, it's everybody's cell phone.
So landline.
It's different services.
So are we-
And a landline will work for everybody. And my request would be that you install a Verizon landline so that if people staying there have an emergency, they can pick up the phone and someone will be on the other end. Because that's what we live with here in Rappahannock, is that some cell phones work, some cell phones don't. And it would, you as a renter, if some emergency arose or whatever, and
Okay.
the people couldn't contact the emergency service, so I think that's relevant.
Is it any other questions or? Okay, you can just stay here for,
Okay.
just stay here is fine. I'm going to open the public hearing. Is there anybody who would like to speak on this application? Yes, ma'am. If you could identify yourself.
Francis Knox. property right behind her, object to the tourist home number 1, the smallest of the lot, the smallest of the house, whole house not being rented, the master bedroom is off limit. She has no room for nobody to stay.
Okay.
Could you say that a little louder? I didn't catch it all. This room is small and what?
The lot is small, the house is small, it's not 720 square feet, plus there's no permits they pull for the air conditioning, the closed-in porch, and the deck.
You're saying that they did not pull a building?
Tom
permit?
Taylor did not before they bought it. So there's things there that need to be taxed also.
Actually, Tom Taylor did, I checked and before I bought the place, and it was
You
full.
can direct it to where
It's not on record in condition.
Okay, hold on. Direct it to us if you will.
It was, before I bought the
okay.
place, I made sure that everything was full.
So you're, okay.
Do not have it on record in the Commissioner Revenue
Okay,
Office.
okay, that's fine.
So,
Did you check that?
yes, I called today.
Okay,
So,
thank you. Is there anybody,
Someone wants to say something.
well, Michelle?
A question was brought up, if it was a two-bedroom home, and I verified through the Commissioner Revenue's office today, it is in fact a two-bedroom home.
Okay. You'd like to speak?
Yes, my name is Ron Weaver, and I live next door to the property. So I'm concerned about the noise and the traffic. This is a quiet neighborhood, and I like knowing my neighbors, and I'm really concerned about that as well. I prefer someone that's going to rent the place permanently, or at least long-lasting presence there. I think there's just be too many people coming in and going out, plus our friends coming in and going out. I think that could be maybe a security issue there.
Which side of, like if you're facing from Water Street, which side?
Pardon?
Where is your house?
22 Ward Street,
Which, like if you're facing
like
the
side by side.
on the left? Okay,
Left facing it or what?
You're facing my house, he lives on the left.
okay, thank you. Barbara?
With the risk of aggravating my President Francis and Ron, I
If you'd identify
I'm sorry,
yourself.
Barbara Dolphin. I had the house on Water Street for 12 years as a vacation rental house. Ron Frazier, when I got that permit, said, I'm afraid all those city folks are going to come and have a party and disturb all the neighbors. Billy Dodson lives next door to me, never complained once, because we never had any complaints. People don't come in and just run raucous. And you get very nice people. In 12 years, I never had a complaint of a 3-bedroom house and a 4-bedroom house. And I know, I understand what the fear is. It just didn't happen. They were just nice people. They came in for the weekend and then they went home. They spent their money on groceries. They spent their money on massages. They spent their money on gifts. They spent their money on dinners. But they went home, and in 12 years, they never one complaint. You know, Billy would have said something to me about it. So, I understand the spirit of it. And so your concern is too.
Okay, Dodson.
It just didn't happen.
Okay, Barbara.
Didn't happen to you.
Could anything could happen. It just didn't happen.
Okay, thank you. Is it anybody else? Please.
My name is Susan Huff, and I live right behind Barbara Dolphin. I don't have any problem with it. I understand people's concern, but I think it's a great idea, because it does bring people to our town. I really do. So I support it.
Is it anybody else?
Robert Archer, aggrieved neighbor. I've had the pleasure of getting to know Susan and her partner Tyler, excuse me. And I don't think they would let anybody in their house that is through POS.
What does that stand for?
He's a chicken.
What?
Not very nice.
Yeah, it was a
I support the application. I've lived here now for years. I own and operate a business here in Sperryville, and I've seen nothing but lovely people that stay at our Airbnbs and B&Bs. So I hope you approve the application.
Thank you. Is there anybody else? Okay. Okay, I'm closing the public
I
hearing.
have one more question.
Yes, please.
What is the length of time people are going to stay there typically?
I guess a long weekend, Thursday to Monday, haven't thought out the details, getting the
But
approval.
they're not gonna stay there like a week or 2 weeks or something like that.
No, that's not the plan as of now.
Okay, thank you.
Okay, since a couple of issues were brought up about the building permits and everything, I'm sure we can require that those are up to speed if they're not. Do we have any further discussion or questions? Yeah.
Well, one of the things that we've been hearing applications from other tourist homes and short-term stay places, and citizens and neighbors were concerned. If there's a ruckus, then you call the sheriff's department. Just call them. And, if it's 2 o'clock in the morning or 10 o'clock in the morning or whatever time it is, if there's loud music, if there's hooting and hollering, then you call them. And when we had this one up in Old Harris Hollow, the sheriff herself, I believe the sheriff herself came, and she said that over the years, there's only been 1 or 2 or 3 complaints, and she really couldn't even recall what they were. So, if you have an issue that's about any violation of an ordinance, one would call the sheriff's department. And they've been responsive for everybody else, so they would be responsive for them.
Chris?
I have some experience in this situation. I've had an Airbnb rental on my farm for 4.5 years. I look on it as a lesser use than a full-time rental. They tend to be people that come on Friday evening and they leave on Sunday. As has been said, so far there have not been any complaints or problems that have been registered with the sheriff yet in this county. And I feel that it's remarkable to me the fear and concern engendered by them when there really hasn't been anything to be afraid or concerned about. And as a county that is trying to promote tourism to enable the local economy, this is a critical aspect of that effort, having places for people to stay in our county that are affordable and family-friendly, which these particular entities tend to be. So I happen to support them.
Okay,
So you said 2 people, and that's 2 people and not kids?
Well, I guess an adult and child, that's 2
2
people.
humans.
2 humans.
2 people.
This is a very small house. And they are not offering up the master bedroom. It's a bedroom, a small kitchen area, a tiny living room, dining room. It's not a party house. It's not going to be a party house. And I think it's going to be a small situation. Yes, 2 people.
That's one reason we said
But,
2.
And the rental room is on which side of the house? Water Street or the other side?
It's on the side,
On the side,
towards the back.
between, okay.
On the picture up there.
Oh, right, okay.
Right here, it says guest bedroom.
So is the center of street shine above is Water Street, correct?
Yeah, Water Street's that way.
Yeah, okay. David, do you have anything to share? No?
I mean, I think you have to put those conditions about the sign, limit the sign, and then it's going to terminate if she sells it.
Okay, and I would just comment, I would reaffirm what Chris said, which is, I've been on this board since, I think I looked it up, 1990, which seems like a long time. Well, I can show you the letter. when I was a police. It was in 1990, because I did look.
But I was here for,
Well, all I can say is when you've been on the board for so long that you can't remember anything about it, maybe get on.
Okay, so anyway,
Who's on first?
but I've not recalled problems. I mean, there's all.
You don't recall when you got on the board, so.
Right. No, I do, because I looked at the letter. I don't recall, I recall a lot of speculation about problems, but I don't really recall real problems. And typically, we haven't heard anything about them, with a couple of minor exceptions, after they get approved. So some of them have gone the wayside, but some of them are still functioning. And it's been typically not an unpleasant experience. And I'm thinking with this, I feel good about the fact that it's fairly restrictive and it is limited to 2 people, so. And the parking, I guess, is where it would be if they were a single family dwelling.
Maybe it would make the neighbors happy if you put a 2-year review on.
we could do that.
We can do that.
And then if they have problems, then
Come back to you.
they can come back and talk about it. when
So
they review it.
basically what he's saying is, and we've done this multiple times, is, to alleviate some concerns, it can be reviewed after 2 years.
I don't put in a new application, it's just.
No, you just come.
It's brought forward though, and anybody, if somebody had something to contribute about the experience or problems,
Sure.
then it could be brought up, and I think we do have the right to establish more conditions or restrictions, or if it's too bad, we could conceivably terminate it as well. So, okay, well, do I hear a motion?
I make a motion to have a review in 2 years.
Well, what about the permit itself?
First, you ought to make
Oh.
it approve it.
Yeah. What we should do is just have a motion to, if the pleasure is to approve this permit, subject to what conditions? Do you
I
want to do
think we
that?
need to be specific on the conditions.
Do you want to do that?
The motion.
Do you want to make the motion?
I can make the motion, yes. I will move that we approve the motion with the condition
Grant the permit.
to grant the permit, based on the recommendation of the planning commission, and that the fire extinguisher, be it 2A, 10BC, appropriate smoke detectors, which the applicant has agreed to, and carbon monoxide detector. And
Are you wanting to require a landline?
Andy Landman, yes. And I think that's important in that area because it can be a problem and people do need to communicate.
How about the review?
And the sign,
Review
the small
period,
sign.
I would say that the review period can be at the discretion of the zoning administrator. And that if there are complaints that are filed, then yes, she can bring it up. But I don't think should be required that it, come up to us in 2
But not
years.
more than
If
2
there's been
years.
no complaints, there's no reason for that to happen.
Well, I mean, it does give some
Either
certainty.
put it on or not put it on.
Yeah, it does give the neighbors some certainty.
Well, but if they complain,
Then
if there are
she can bring
complaints
it
to
to
the
us,
zoning
but it-
administrator, she brings it up and puts it on the
They don't
agenda.
generally complain to the zoning administrator, they would complain to the sheriff. And so that it seems that by having a review scheduled, that would kind of bring it to the fore.
Are you willing to just add a review?
You're lucky,
Okay,
down in
that's
my
fine.
district, they
That's
complain to
fine.
me.
Okay,
That's
so
fine.
he's adding the review.
I somehow think that if the sheriff is receiving complaints, that in those situations, they should be channeled through to the zoning administrator, but that's another.
Okay, do you understand
The
what
sign,
he said?
Yes.
don't forget the
And the
sign.
limitation of the sign to what? Just to address?
Address, that's all you need. I've been to B&Bs.
What size? What a size
What
limitation.
size? 2 by 3 square feet?
Okay, I'll do what I did the last time. It has to be the luminescent
Blue thing.
address signs that the fire department and emergency services can see coming down the road.
And it terminates, and the last thing is it terminates if she sells it.
This is for her ownership.
And, okay, and for her ownership.
Okay, you understand all
Yes,
that?
yes, I do.
Okay.
Very good.
So everybody's on
Almost
board?
no problem.
Everybody is on board.
Okay, is there okay, there's a motion, is there a second?
No, I'm not second.
Is there a second? You made the motion.
No.
Oh,
Ron did. I
Okay, second, okay. Any further discussion? All in favor?
Aye.
Aye.
Opposed?
Abstain,
Abstain,
for the reasons I already stated many times.
okay, thank you. And what was that? I forgot.
He's
You
already.
forgot?
I don't think it's a tourist home that fits the definition
Oh,
that's in the zoning law.
Okay.
Sorry.
Okay, the next item, which looks like it's our last item,
You're kidding. What is it?
is the 15 Main Street LLC zoning appeal. And, okay, I'll sign this real quick.
Who's our governor?
Okay, so, if everybody's ready, are we ready? Yeah, we're ready. Okay, so our rules of, okay, so our procedure starts with the zoning administrator giving a presentation, and then we do show and hear views of the general public and the applicant. I mean, and the applicant.
Tell me.
Is that severe?
Yes.
Okay.
Severe.
And then Michelle, who's the zoning administrator, can rebut some of the arguments if she sees fit, and then we'll have discussion. So I'm going to start with the zoning administrator, Michelle Summers, giving her summary.
I don't need a microphone, I'm loud.
Okay.
Basis for this case is that my office received notice of a sign, notified the applicant by letter that any signs that were placed within the county did need a zoning permit, and told him what the size limitations were, which is in village residential or village commercial is 75 square feet. This was based on the county's code definition of a sign. Any writing, a letter, or numeral work, pictorial presentation, illustration, or decoration, emblem, device, symbol, or trademark, flag, banner, or pendant, sculpture, or any other device, figure, or similar character, which is used to announce, direct attention to, identify, advertise, or otherwise make anything known. With words, we're making it known, hey, we're in Sperryville. Visible from the public right of way or from adjacent property owners. It's very visible. What my office was saying is that he could not, we're not saying, no, that sign has to go away, it's not permitted. All we're saying is, it is a sign, it does require a permit, and it is to comply with the county code, which sets the square footage size limitation of 75 square feet.
And does his other sign count towards that 75?
It does.
In
The total square footage, which is allowed, is 75 square feet.
So I don't know if you have a picture of that. He's got one on the front.
Yeah.
So we're talking about the total, according to your position, the total.
This
sign.
was the first sign that went up.
This Berryville Main Street was?
What I have on the screen is the other circular sign, in which he did come in and make application for zoning permit.
For that sign?
Yes,
So that one is permanent.
yes,
And that's when it says actually happy camper
yes.
and 700 and something. That square triangle. Okay.
To the next page.
Oh, there you go. Thank you.
Okay, and that's more or less for the business,
Correct.
and that's really what it's.
What about, go back to the previous page if you would. What about the door with the H, isn't that a letter or whatever, does that count? Or not? Square footage of that?
I mean, it doesn't look like it.
What?
Their door handles.
Oh. well,
Yeah, I
looks-
mean, let's
can't-
not get hung up.
I didn't know it was door handles, I thought it was the name. Okay.
I'm a little confused here in that I thought we were receiving testimony
We are.
from the county or the
Okay.
zoning administrator, and that
You're
his
right.
questioning would come on later.
You're
So
right.
let's try to,
You're right. Okay. Is that,
That's it.
okay, that's all. And I'm imagining we could entertain clarifying questions from the board if they're ready.
I've got some.
You want to ask her a question?
I do. So this letter that you sent was dated, what was the date you sent?
May 16th?
I'm asking her, not you.
Yeah, hold on.
I was going to help her by getting her.
Okay,
It was April 17th, 2018.
the first letter.
Okay, and then,
That's an email?
No, that is a letter.
Okay.
and I understood from, I guess it's your statement in the previous thing or something, or maybe it was in what he submitted, that Mr. Chapman, and he came in and made an application, is that right?
Yes,
And what date was that?
it's written on that letter.
And that's for a sign permit for the sign?
For variance.
Oh, the variance, okay.
So May 9th, he came in.
Okay.
And what happened on May 9th?
He made application and picked up a variance application.
I'd rather if she sent.
He made application for the sign that's on the television, the Happy Camper sign. He does have a zoning permit for that specific sign, but then,
That was when? That was May 9th?
yes,
Okay, and what about the Welcome to Sperryville?
there is no zoning permit on file for
But
that.
did he apply for it?
No, he applied for a variance for that sign.
On what day?
He took the
Picked
application.
up a variance application.
Okay, and what day did he file?
I mean, does that really matter?
Going?
It will. The variance is not official.
May 2nd.
May 2nd.
Well, how did he pick it up on May 9th and file it on May 2nd? Says, this says he picked up the variance application May 9th.
Okay.
So how could he have filed it on May 2nd?
That date's wrong on there.
Maybe that's the second.
Okay, is it somewhere you're getting at with this?
Yep.
Okay, can you just, it'd be interesting to know what that is.
Well, I want the answer first.
No?
The variance was applied for on May 2nd. I have the application right here dated.
So
Okay.
this must be wrong, the variance application. This
Yeah.
date, okay.
But the application for the, all right, do you have that you can put up on the board?
The variance?
The variance application? Or is that in the other board?
It's another board document.
Listen.
So would that have been the May meeting? Yeah, it probably was May.
There we go, right there.
She's got
May
it.
23rd.
I know it is not coming up.
That's easy now.
All right.
That's fine.
Here we go, here we go.
I got it.
She's you have his.
Yeah, May 2nd, dear zoning officer, Board of Zoning Appeals.
May 2nd.
Okay, so who, did you fill that out, or did he fill that out?
I did not fill that out.
I mean, he came in, it was already filled out, or what?
When it was brought in, it was filled out.
Okay, and he just filed it.
Can you roll it down and see who signed it?
Next
Oh.
one.
Okay.
Okay, and he gave you these checks, or a check?
Yes, sir.
$400?
Yes, sir.
Okay. Well, right now, I think that's all the questions that I have.
I think I'm fine as well.
How many complaints were filed on the sign?
What's the relevance of that?
At least one.
At least one.
What's the difference if it's complaints?
I would like to know how many complaints were filed on this sign.
It was a couple. By state law, I am not allowed to give out names.
No, I realize that, but I was just looking for a number.
So two, say two.
2 to 3.
2 or 3? Okay.
Okay, 2 or 3. Okay, is that satisfactory? Okay, so now the appellant, and your background, appellant.
There you go.
I like applicant because it's consistent with
With the.
It could be severely.
Yeah, appellant. Shall we come here? Yeah, oh, sure, you can come up here.
Swear 'em.
Well, I can swear it, but Archer when he's ready. Right, go ahead.
Would you like to?
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do. Thank you, Mr. Chairman, and thank you again for allowing me to speak out of order earlier this evening. For the benefit of those who don't know, my name is Michael Brown. I'm an attorney with Walker Jones here, representing the appellant, I like applicant, 15 Main Street, LLC. The appeal that you have before you this evening states a number of grounds for the appeal. There are just a couple that I'm going to touch on primarily in my remarks, and then I'll turn it over to Mr. Archer. The first is that our contention that the mural that is under review is not a sign within the meaning of the ordinance. And first off, I'd like to direct the board's attention to the definition in the zoning ordinance of what a sign actually is. And Ms. Summers has already read it, but it's worth focusing on again for a moment, and that is any writing, letter, or numeral work, pictorial presentation, illustration or decoration, emblem, device, symbol or trademark, flag, banner or pennant, sculpture, or any other device, figure, or similar character which is A, used to announce, direct attention to, identify, advertise, or otherwise make anything known, and B, visible from a public right-of-way or from adjoining property. It struck me, I hadn't planned to make this observation, but I noticed a number of folks here in the audience this evening are wearing T-shirts that have the exact same markings on them as the mural that's in question. I can have them stand.
No.
You'd have to turn around.
They're even in the same. They're even in the same colors. It strikes me that
Maybe they all need sign permits, huh?
that Mr. Connick has already made my argument that by
Get their names, Michelle.
by applying the definition of sign in as broad a fashion as the zoning administrator does in her notice of violation letter, May 25th. All of those, provided that they're visible from the public right of way. So I guess if they're standing out in front of the courthouse rather than seated inside the courthouse. Every one of those T-shirts would meet the definition, the definition in your ordinance of sign that you're called upon here to consider this evening. Our contention is that this is just what I described it as. It's a mural, it's a work of art. And it's not a sign, not intended as a sign. It's not intended to be regulated as such under the county zoning ordinance. It's also worth observing that the sign ordinance recognizes a number of exceptions to the signs that require permits. None of these are mentioned in the zoning administrator's notice of violation, so it's not clear whether the zoning administrator considered any of these exceptions. They appear in section 170-94 of the zoning ordinance, and they include, and I'll just touch on a few of them. Chairman,
Oh wait, this is from 1990.
did you bring your view book? Those exceptions include
Where are you reading that?
170-94, permit required. And then the second sentence says, provided, however, that no such permit shall be required for, and it enumerates a list that's almost as long as the alphabet, not quite. It stops at letter
Oh,
S.
an S.
But it includes C, memorial tablets or signs and historic markers. F, flags, emblems, or insignia, I'm not going to read that whole thing, but of the United States, Commonwealth of Virginia, Rappahannock, other counties and states, et cetera, religious groups, civic organizations, and service clubs. Letter J, seasonal displays and decorations not advertising a product, service, or entertainment. M, any informational or directional sign or historic marker erected by a public agency, which may include signs giving directions, et cetera, et cetera. Skip to the last sentence. Provided that no such sign shall give directions or distance to any specific business establishment. Something to bear in mind then, as the board members consider this appeal, is that the ordinance itself again calls out numerous exceptions. I just quoted a few of them. That make it clear that there's not an intention to regulate a whole broad classification of signs if in fact this mural is deemed to be a sign within the contemplation of your ordinance. That this mural would fall within one that is merely words, announces the location of Sperryville, its establishment date, and it's not related to any specific business or intended to advertise one. Secretary Connick forwarded earlier this afternoon to the board's attention a case. I love the style of the cases, Wagmore Dogs. I always enjoy when I get to cite a case that has an entertaining name. The Wagmore Dogs case, which I was in fact prepared to address in case any of the board members were familiar with it, because it has facts that on their face are similar to the facts in the appeal before you this evening. But I wanted to be sure to draw the board members' attention to a couple of very important distinctions between the Wagmore Dogs case and this case. It's a first and foremost, it's a First Amendment case. It involved whether Arlington County could regulate an advertising mural, or whether their attempts to regulate that exceeded the limits of the county's powers on First Amendment grounds. The distinguishing characteristic, one of them, is that for purposes of that case, as best as you can tell from the opinion, including the opinion beyond the one that Mr. Connick provided to you this afternoon that went to the Fourth Circuit, is that it was assumed for purposes of that case that the mural that was at issue was in fact a sign, that it fell within the county's definition of a sign. And that's a distinction that's vitally important to this evening. That was, I believe, largely because, on the facts of that case, largely because that mural did have advertising elements. It included.
Beg your pardon?
That mural did have advertising elements to it.
You go read the case and you'll see all it had was pictures.
But the advertising elements were in fact the pictures. It was depictions incorporated in that mural that used the business. Now again, the mural was on the back side of a building in which the business was located. And that mural incorporated pictorial elements that were used in that business's advertising materials. They were specific cartoon characters that were built into the cartoon depictions that were in that mural. And for that reason, I think it was accepted for purposes of that case, it was a sign, because it was an advertising, that was subject to the sign law. Again, that's not the case here before you this evening. We're not at that point. The primary contention is that this mural, this work of art that you're dealing with this evening, is not in any way a sign. It's not an advertising. It doesn't incorporate any of the business's advertising elements. It merely shows what it shows, as you saw in the picture earlier. The other issue I wanted to raise, be sure to raise, that is mentioned in the appeal materials that you have before you, is a concern that's related to the application of the zoning ordinance, and specifically the uniform application of our zoning ordinance to all properties and property owners in the county. There are numerous zoning cases, it probably goes without saying, but I'm a lawyer, so I'll say it.
We're learning these things.
That repeat again and again, that it's a consistent and uniform construction and application of the county zoning ordinance by the officials that are charged with its enforcement. That's critical. And where that's shown, that's entitled to great weight. I can cite you cases, but there are numerous cases that use that language in Virginia. The appellant has pointed out in his application that notice that there are a number of readily visible signs, and these are what would fall within our customary definition of a sign as opposed to a mural or a work of art, that exceed the dimension restrictions in the zoning ordinance. Those dimension restrictions are found in section 170-107A1. Ms. Summers has already mentioned it. In Commercial Village, it's a 75 square foot area limitation. It's worth noting that in the resource preservation and residential district, the size restrictions are even smaller than that. We're probably all aware, and this evening as we sit here, of a number of signs that are vastly exceeding in size the restriction, the size limitation. And I'd ask that the board bear in mind that that's a concern, and it's one that's raised by the appellant in his appeals material. At this point, I would introduce Robert Archer, who's the principal in 15 Main Street LLC, and who would like to address you with some comments of his own.
Yeah, thank you. Board, appreciate the time. Robert Archer, doing business as, Robert Chapman, DBA Robert Archer, sometimes to friends, in my capacity as Robert Archer speaking to you tonight. I hope you consider my original intent and will in execution of this mural. Couple that with filing permits for building, filing my commercial brown happy camper sign permit. All of these things point to character, not to evade the law, not to step outside of our ordinances, but to comply. This exercise has actually been a community building exercise. I feel like I've heard from countless people across the county that have rallied and supported, and I think 2, maybe 3 complainants out of a county of 7,500 people is not so bad. I've heard from people in Richmond that visit our county that said that they would not have visited Sperryville had they not seen this Welcome to Sperryville mural. So, I mean, there's identifiable economic impact. People have said they stay in Sperryville for 1 or 2 nights, go shopping, visit our restaurants. That's not what's up to debate tonight, but I hope you take into consideration my intent in painting the mural. I think the village got a freebie. I've been thanked up and down. You can see the people here tonight wearing their t-shirts, standing in solidarity. So I appreciate you considering my intent in painting this.
Thank you.
Mr. Chairman, we don't have any other witnesses that we intend to call specifically in support of the case. I expect that you'll hear from probably a number of aggrieved persons, as we've come to appreciate Mr. Call, as well as probably some other citizens that may not fall into that classification, that I hope will speak to to whether the sign, if it is a sign, if the board finds it to be one, whether it violates in any way the intent of the sign ordinance, which is to protect property values, to encourage the most appropriate use of land, secure safety in the streets, to achieve a more desirable living environment, to protect and enhance the attractiveness of Rappahannock County. I think that you'll hear some comments in that respect. So in short, we would respectfully request that the board overturn the decision of the zoning administrator in her finding that the mural, the work of art, is in fact a sign that's subject to regulation, and that it kind of violates the size limitations of the commercial village district. Thank you.
Okay. I was just going to ask a couple of quick questions, if you don't mind. So if I can understand your argument, A, it's not a sign, it's a mural.
The work of art, it's a mural.
Okay, that's your first argument. In the event it is a sign, you're saying that it's no permit required because it falls in an exception.
I'm saying it's not clear from the zoning administrator's determination whether she in fact even considered any of the enumerated exceptions.
Are you saying that it is or it isn't? Which one?
No, I mean, I'm just asking that same question. You cited section C and M.
See,
Yeah, let's just go through them one at a time. Are you saying it's a memorial tablet or sign or a historic marker?
Could be considered a historic.
How could it be considered a historic marker? Historic markers on those like Civil War things.
My point is, in your mind, you've already reached a decision as to what a memorial tablet or sign or historic marker is. But isn't it the case that somebody else looking at that definition, I don't think that there is any in the definition section of the zoning ordinance, it's spelled out what a historic marker is. In this case, it says welcome to Sperryville.
But you're not saying it's a historic, you just said it's a mural.
Hold on, this is
Well,
just
wait a
a
minute.
question.
I know it's just a question, but I want to understand what you're saying, because first you said it's not a sign, it's not, and it's, you said it's a mural. But now are you saying it's a memorial tablet?
I'm not. I'm sure you're familiar with the concept of arguing in the alternative. Our first argument is, in the first instance, it's not a sign subject to the regulation of the sign ordinance in the first place. If, however, it's the determination, as it was in this case, the zoning administrator, she gives us no indication in her notice of violation if she's considered any of these exceptions and whether they apply or not. I'd ask the board to consider some of these exceptions this evening. I'm not suggesting to you that this mural, if in fact it is a sign, falls within each one of those. I'm simply bringing those to the attention of the board. The board,
You're saying
for your consideration.
Okay, that's fair. That's all.
You have more questions?
I think that's all. Thank you.
Well, I was going to continue on. You mentioned J, seasonal displays and decorations, not advertising of product, service, or entertainment. Doesn't that mean like a little Santa Claus thing that says Merry Christmas or Hanukkah Harry?
It could be Hanukkah Harry or a Festivus pole, Mr.
Or who?
A Festivus? You're familiar with it? I'll have
All right, and what was the other one you mentioned? M.
I mean, M seemed to be the closest.
Well, it says erected by a public agency. Well, you're not claiming that 15 Main Street LLC is a public agency, are you?
Not in the least.
Okay.
I am not.
Great. And now, were there any others that you mentioned? I don't think
I
so.
believe we covered all.
Okay, all the ones that might apply. All right,
And then,
can I go ahead with my other question?
Sure.
Great. All right. When you talked about this Wagmore Dogs case, I was very interested in what you said. And I'm going to get it out. And it says, as part of the renovations, the owner commissioned a local artist to paint a mural of dogs, dog bones, and paw prints on the rear cinder block wall of the building. And somewhere in the actual decision, there's a picture of it, but I don't have that.
I don't have it either. I wish I did.
But apparently from the discussion that's here, it didn't have any words and it didn't have any letters, right? Okay, it says dog, I was like concerned when I saw the dog bones. Does that mean the kind of dog bones you feed the dog, or does it mean the bones of dead dogs? Anyway, that's what it says. Mural of dogs, dog bones, and paw prints on the rear, so there was nothing but pictures. And to me, that's a mural. And they called it a mural. The mural faces the Shirlington Dog Park.
May I add to your description, Mr. Conley?
Well, go ahead.
Because in the opinion that describes the mural that came out of the Court of Appeals in the Fourth Circuit, they went on to mention
I got that too. Let me get it here. Here's something.
a picture of it. You have a picture of a white dog?
No, I don't.
What is the thing called white?
All right, wait, I'm printing it out. Just a minute here, I've got it.
What the, interview with wag,
All right, what do they say in the Fourth Circuit when they affirm it?
This is under Part 1, Section B, first paragraph.
Is this all really relevant?
I think it is
a discussion between lawyers.
I think it is, Mr. Macklin. Okay? Since Mr. Cox raised the question. The final product is referring to that mural. This is, I'm quoting from the Fourth Circuit. The final product measuring approximately 960 square feet, so almost 2.5 times the size of the mural.
What page of it are you in?
Well, when I printed it out off the website, it's page 4.
What section of
There's a centered letter B, first paragraph. Last sentence of that. The final product, all right, measuring approximately 960 square feet, so again, I want to note, almost 2.5 times the size of the mural in question. Incorporated some of the cartoon dogs and Wagmore dogs as logo. And then it goes on saying, Houghton described it as including happy cartoon dogs, bones, and paw print. The point being that that mural did bring in elements of that business's advertising product.
But you already referenced your clients putting out T-shirts and printing T-shirts and selling T-shirts with the exact same thing on it. So isn't that the exact same situation?
Those are T-shirts, aren't they?
Huh?
Those are T-shirts. Or are you suggesting they're signs?
No, I'm suggesting that it's part of his business now.
Okay.
I'm just asking. All right. Well, I didn't understand what you said, that this is somehow a different kind of case because the thing that you later endorsed that your client wrote and filed cited a California case, the city of Indirio versus, I forget who, and
which is a First Amendment case.
Which is a First Amendment case, right? And then cited a mural is not a sign case from Illinois, which also was a First Amendment case. And those cases found that somehow, well, the one was some kind of a cultural thing. The California case involved some cultural aspects of Hispanic and Indian culture were on their mural, and they said it was an impermissible restriction on free speech. Because, and it was pointed out in your memo that was filed that you endorsed that somehow it was therefore non-commercial speech. But their zoning ordinance in California, as well as the one in Illinois, as well as Arlington's, made a distinction between commercial advertising and commercial signs and other signs, which our zoning ordinance doesn't make. Right?
Okay. I think if you look at the exceptions in your zoning ordinance, Mr. Connick, I think it's very clear that the exceptions are intended to call out all kinds of exceptions that will lift.
Right, but wait a minute, what I'm asking you is,
permit me to answer?
what I'm asking you is, there's not a classification on restrictions of commercial signs, and then a different set of limitations on non-commercial signs in our ordinance.
That the ordinance does not define a commercial sign as something being separate from non-commercial sign. I'll concede that point, Brett.
Okay.
But I will also note, again, for the benefit of the board member, that your ordinance does call out a number of exceptions in that section 170-94 that are clearly intended to lift certain groups of signs that are described as not being for advertising purposes, for
Okay.
example, out of the
They do.
restrictions of your
And
ordinance.
it's also a well-known legal maxim that expressio unius est exclusio ulterius. When you put a list in of the exceptions, that's it. If you're not in the list, you're not excluded, right?
I think the board can consider whether, if in fact this mural is a sign, is it included under one of those definitions?
All right, now I have some questions for the applicant, because he testified. Mr. Chapman, you filed this application for variance on May 2nd. I mean, you heard Michelle's, so what her testimony was accurate?
May 2nd, under her direction, I filed the
Well,
application.
I didn't ask you about under her direction. You got the letter and you brought in the variance application, and filed it, right?
No,
No, what?
I received the letter, asked
All right,
Michelle.
tell me your version of it. So you
I'm
got the
about
letter
to.
on April 17,
I'm
right?
about to, yeah.
All right, and then what happened?
I came in, asked Michelle, what is the way to appeal her decision? She said I needed to file a
Okay,
variance
just a second. You came in when? Or approximately when?
approximately before May 2nd.
Okay. So sometime between April 17 and May 2nd, you came in? Okay, and then on May 2nd, you filed the variance? And that's your check from Happy Camper Equipment Company, and that's your signature on it?
It is.
Okay. And in your application, you described what you put up as a sign, did you not? I mean, is this what you submitted?
That is what I submitted, that's what I
Okay.
painted on the side of the building.
Okay, and it says signage variance request, right? Okay. And in your letter, you said you hereby request signage variance consideration by the enclosed application. Right? I'm reading from your May 2nd letter. That's your signature on it?
Okay. Quote unquote signs, yeah.
But I mean, that's your signature, no?
It is.
Okay. So this is what you submitted, and it says, applicant is seeking variance for the hand-painted Welcome to Sprayville wall which falls under purview of Article 12 signs of Chapter 170. That's what, I mean, she didn't write that, you wrote that, right?
Okay, but I'm also not an attorney,
Well,
so
Okay.
I can be forgiven for,
and then in the next section, you said it stipulates no more than 75 square feet, and you said you want applicant is requesting use of a 25 by 20 foot tall section of the wall for continued use as a welcome sign, right? That's what it says.
That is what it
because
says.
that's the variance process, was to use that side of my building as a mural / sign.
Well, but you didn't say
My
mural
language,
/ sign.
my
You said
language
sign.
in this, the self-service nature of this application, my language is my own.
All right.
I'm not an attorney.
Okay,
I was not
I'm
advised.
not asking that, I'm just asking what
Actually,
you
I'm going
said.
to offer a suggestion on this. If he were to have come in and said, my mural is not so big, would we still be deciding whether it was a sign?
Well, I don't know, but he's the
I
one
think-
who put it on the table that it's not a sign.
I mean,
So
I think
For the benefit, for the benefit,
maybe irrelevant.
for the benefit of the board members, I mean, what Mr. Connick wants to suggest is that
He was
is that he's now stopped, is that the appellant is now stopped from suggesting in his grounds for appeal that this is somehow not a sign. But we're not here appealing that. You know, that, again, the variance matter went forward, it came before this board.
Well, he withdrew it, so it's a good point. I'm just,
Right, the appellant was advised that that was not the proper procedure, he withdrew that. And what we're here about this evening is an appeal of the zoning administrator.
of the original
May 25th,
determination, right?
Of the May 25th determination letter, that's what we're here
Okay,
on.
great.
So, I mean, whether...
I'm not done with my question.
But I'm saying whether he admitted or suggested it was a sign or a mural is probably irrelevant.
I don't know if it's relevant, I just want to know what the facts are. I'm just trying to get at the facts. And whether it's relevant or not, we'll decide when we come with it here. I
and discuss it. So my next question is, you say, could you put up his appeal, give me a copy of the sign somehow? It doesn't
The actual
Is this one? Or no, the one on the
Not the
16th?
variance, the actual, the one we got now. That's the old one. The appeal that we're deciding, the variance application. That's not it. That's it. Next page.
I'm sorry, next page.
Next page of the written part, of the typed part. Keep going. No, keep going down. Right, hold on. Okay, keep going. Keep going. Right there. So I'm reading this part that you wrote and filed. This is emphatically not an instance in which the applicant knowingly failed to seek zoning approval.
Correct.
Is it true or isn't it true that you had a conversation with Debbie Kaiser, the former zoning administrator, before you painted the mural?
Not true.
And you didn't ask her if she thought it needed a permit and she told you it did?
Don't recall that
You
conversation.
don't recall it, or it's not so?
I don't recall that conversation.
But you had a conversation with Debbie Kaiser about it?
No, I don't recall that conversation at all. Were you there
Because I
for
don't
that
know.
conversation? Then why do you think this conversation exists?
I'm asking the question, that's not you.
Yeah.
Because somebody told me that they were told.
Actually, I'm considering clearing the room if you can't behave. Okay?
Somebody told me
That we have to
that
behave.
Debbie Kaiser told them that you had that conversation.
Are they here tonight asking questions?
Okay,
I don't know if
let's,
they're here.
We're getting beyond hearsay here.
Right.
We-
Well, I wanted to know if he was going to
Well, he
admit
says-
it or deny
he
it. So
says
he
no.
denies it, so
He
it's
says-
denied.
It says it didn't recall.
Okay, fine.
now, do you have any other questions?
Not right now, I don't think so.
Okay, is it any more from the board? I think the audience will have a chance to speak here in just a minute.
Okay, I have one question. When you got the application for the variance from the zoning administrator, was that at your, did you ask for that variance form, or was it given to you by the zoning administrator?
I asked what the correct format was to appeal her decision, and she furnished me with a variance application.
Very good, thank you.
Anything else?
Pizza.
Okay. Okay, is that adequate for now?
I'll ask one question.
Yeah, okay.
I think it's wrong. Has it ever been your intent to circumvent the sign ordinance in Rappahannock County?
Never. Any questions? Okay, so I'm going to take the risk of opening this to the public. Yeah, you can start. Thank you. Okay, so initially, and I don't know if anybody here really fits the aggrieved party.
That's property owners.
Okay,
Why
adjacent.
don't you ask them first? Is there any adjoining property owners here?
That's one thing.
Great.
Okay, so adjoining or close by property owners who would like to speak, we'll let them speak first. And if you'd like to,
Other next door, 21 Main Street.
can you identify?
My name is Tony Lovato, and I just want to say I have no objections to it.
And you have no objections to this being ruled as a mural or as a sign, or what are you not?
Not at all, I consider it a mural.
You consider it, okay.
Say your name again and what?
It's actually, for the record, it's Anthony Lovato,
Anthony.
21 Main Street.
Okay.
Okay. Is it anybody else in a similar position?
John McPherson, 3 Blacksmiths, 20 Main Street. Enthusiastic supporter of the mural. The mural.
Existence of the mural or call determining its mural? Not a size.
The mural in every way that it is.
Okay. Is there anybody else similarly? Okay, Martin?
Martin Woodard. I own 2 properties on Main Street in Sperryville, nearby.
Okay, good.
I'm also an artist. I think I understand art when I see it. This is definitely a work of art, which is one of the definitions for mural. I'd also like to point out that I think that this board's role should be as a tribunal and not trying to prosecute the case.
Okay. Okay, thank you. Is it anybody else in?
Sherry Fickle, 47 Main Street. I own a business, 2 properties on Main Street. I also consider this a mural. It is a work of art, and I enthusiastically support its existence.
Okay.
And I echo what Martin said. I guess I would like to add that I think that Mr. Chapman has not been treated fairly by this county. He has gotten some advice that has cost him a great deal of money to file appeals that have then been told are not appropriate. Hundreds of hours of people's time have been spent coming here in order to show support for him, and each time he's told that something's wrong and he must come back. I would hope that our public servants and our boards would treat citizens who are truly trying to do something for this county in a little bit better.
Okay.
Here.
So is it anybody else who?
I'm Robin Day. I live at, excuse me, my voice is gone. 1023 Woodward Road. I live behind his 3 blacksmiths. I see this sign every day, coming, going, and I guess right there I did a Freudian slip. I don't see it as a sign. I see it as a mural. If I were to put the name of my apple tree cottage on the side of my house with the date it was built, would this county consider that a sign instead of a mural? That's something to consider. At what point does it go from a sign to just saying what it is? I feel it's a mural.
Scott Sullivan, 11771 Lee Highway is the family's business. One of our biggest challenges in Rappahannock County is attracting people to live in this area. This mural is beautiful. It attracts people to the area. People come in for job interviews, and we've been more successful. I don't know why, but we've been more successful. I'm not going to draw, one or the other, but since that has happened, we've been able to hire 3 additional employees, and we're doing great. And we really love the mural, and everybody in the business feels that way. Thank you.
Anybody else?
I'm Rachel Bynum. I'm at 53 Watertown Lane in Sperryville on the other end of the village. And I have noticed people coming to shop, coming up our lane, who've said they've stopped on Main Street, they've spent money there, they've had conversations up and down Main Street because they saw the mural, and then they've also come and spent money at our establishment. I just want to add that we started our business here 18 years ago, and if I had had this experience that our new neighbor is having, I would not have felt welcomed. And I think that the support we see here is more indicative of how most of the people who actually are living in Sperryville, rather than the anonymous people who chose to be aggrieved and who aren't speaking up. I just think you should really note that. And we're trying to build an economy, a very fragile, small town economy here. And we need support.
Okay. Thank you. I guess we're getting beyond aggrieved.
I would be aggrieved if it was removed. I think that he has
Say your name.
Oh, I'm sorry. Sarah Haynes, and I live on Woodward Road. I'm not right across from it, but I do see it all the time. I think that he's actually provided us a community service, and I hope that we look for a way to make this object legal. It's not a business sign. It's not promoting his business. It is actually promoting our community, and I think it really has brought us together. And it seems to me, since it says when Sperryville was founded, if you chose to, you could consider it a historical marker.
Who else? Who else? Okay, well, let's say we're moving beyond aggrieved to interested. Go ahead.
I'm on 6 Hopewell, Paul Kirchman. I can just about see it from where I am. I just have a question, which is, if we can't give Robert a variance for this...
This isn't a variance.
Whatever it is. If we can't keep this sign, can we talk about the billboards and take them away? Okay? Because they have to be... They're worse. That's all.
Anybody else? Go ahead.
Daphne Kirchman, I also live at 6 Hopewell Lane, actually have 2 properties within half a mile of this beautiful thing. And I would like to point out, in terms of the advertising, any of the money for the t-shirts is going to the rescue squad. It's not money that's going into his business, and it's not, they're beautiful.
Okay.
That's all. I'm in favor.
And my name's Ray Bach, I'm a photographer in the county. The other day I tried to get a picture of the sign, but I couldn't because people were stopping and walking in front of me to take pictures. So I mean, it causes people that are coming down the road to stop and look at Sperryville. That's great.
I'm Richard Parsons, I live in Middle Hollow in Sperryville. And I think most of us get our power from Rappahannock Electric. And once a month they send out a little magazine that we all receive. And they choose one small town in Virginia every month. And they chose Sperryville last month. And guess what picture they had on page 1? The mural.
Who else?
Hi, I'm Sarah Butler, and I'm a private citizen and a patron of Sperryville businesses. And I just, as also an enthusiast of the legal profession, wanted to point out that I've listened tonight to a lot of semantic sort of arguments about whether, somebody did or did not say sign or mural at various points. And to me, that's not so much a semantic argument as it is a translation argument. I think it's been made clear to everybody here tonight that Robert's history and career as an artist and his enthusiasm for this project was all sort of begun and completed as an artist and enthusiast for the community. And if someone told him that it needed to be called a sign, then he was willing to call it a sign to participate in the process. That's not a semantical argument, that's a procedural argument and an argument of translation wherein the system told him what he was supposed to call it. So I might call it street art, someone else might call it graffiti, someone else might call it a mural, someone else might call it a sign. I think that part is still open to interpretation, but the part that's sort of not anymore, I think, is the fact that the community really is supportive of it. So I hope you consider that about the other arguments.
Thank you. Who else? Okay. I'm going once, going twice. Okay, I'm closing the public hearing. Thank you, everybody, for your thoughts. I appreciate it. Okay, so Michelle, do you have any rebuttals or any comments to make in response to all the information that's been brought forth? Do you have any thoughts about the exception issue that Mr. Brown brought up about whether...
I will state the entire sign ordinance was reviewed before that letter was sent out.
Okay, so
And county attorney did review it before that letter was sent out.
So you feel like this section of exceptions was...
It was reviewed.
The 170-94.
It was reviewed.
Okay.
So you're saying, in your opinion, it doesn't fall under any of the list of exceptions?
That is correct.
And I'm not sure if this is totally proper. Do you have any response to that?
My only observation, Mr. Chairman, would be that the notice of violation doesn't indicate that. I
does not say that you would.
That's right. I appreciate Ms. Summers' comment, and I don't have any reason to think that what she's saying isn't true.
Okay.
But there's no indication that part of the sign ordinance was even considered in making the determination. Okay. It only cites the definition of sign, that this is the notice of violation letter sign. Notice the definition of sign. It says, this is a thing that I say is a sign, and that it violates the maximum sign limits in the commercial village district.
Okay, thank you. And I just, from myself, would like to say to everybody in the audience, I understand there's some frustration about this process and how the applicant is not welcomed or welcomed to the community. We have a somewhat limited role here, but I will say that, and maybe this came from me or maybe from all of the board, but we could very easily have said he did not properly file this permit and that the time period had passed. And I mean, there were several reasons why we could have chosen not to hear this today. And so I think, not that we need to get Citizen of the Year or anything, but what I'm saying is I think we have given the applicant the benefit of the doubt so that we could have this hearing tonight. And regardless of what the outcome is, I personally felt that it was more desirable to give the hearing and to have the public come and see our process, rather than to get it snuffed out in a procedural, not loophole, but deficiency, which I think the Board of Zoning Appeals did make allowance for something that we could have seen the other way just as easily. So that's just so you understand that we are hearing this and we're glad to hear it. So, but I mean, it may or may not turn out the way everybody wants it to turn out, but we are here. So that's, is any other statement or position, questions, comments?
Yeah, I'd like to say that, number one, we're not the Supreme Court of the state of Virginia, we're the BZA of Rappahannock County. And this is, a tough issue for us, because personally, I don't have any problem with the sign. But our code defines it, the mural actually, it defines it as a sign. And what we're deciding here is whether the person that we hired as our zoning administrator is doing her job. And she had a complaint, she looked at the ordinance, and reading the ordinance and looking at what she was looking at, it met the ordinance as a sign. And so she filed a complaint, or filed, talk to the person that had put it up. And now we are sitting here, and basically what we are deciding tonight is whether our zoning administrator made a proper interpretation of the code. The code says what it says. You out there are the citizens of Rappahannock, and if you don't like the code, then we need to make an effort to change the code. But the way I see it, and I don't like having to look at it this way, but the code says that what Robert put up is a sign and it exceeds the limitations, and sadly, that's the way I have to look at it.
Well, I would like to say something, Mr. Chairman, about the... All right, ladies first.
I have a couple things to say, and some of it's a little more personal. I'm a little disappointed that there's not a member of the Board of Supervisors here, because if we were going to...
Christine was here.
Oh, I didn't see her.
She was in the back, but she
Okay.
was here.
Because this has been a really lightning rod issue. And I think that they need to understand that we've got some archaic code levels and we need to be making some adjustments there. So I'm echoing a little bit what Mr. Macko said. and we need better direction for our code. We need to catch our code up on several things, but on some issues with like the tourist homes or the short stay term homes, as well as the signage and so forth. We also have to be aware of the slippery slope. And I've been thinking about this because we could have welcome to Sperryville and welcome to Woodville or something like that. And someone could say, well, you know, I just really, really, really like this point of history or something, and put something up that might be offensive to somebody else. So who's the judge on what is good and warm and welcoming and proper versus something that can be offensive to someone else? I don't think this sign should be offensive with the art that's on it, but there's a slippery slope. So we say, well, you know, we'll go right straight ahead and accept this, and then someone says, well, and I'm going to paint a picture of Mr. Connick on a wall, because, you know, that may offend somebody.
That would offend me.
So we need to review, and we need to review all signage in the county, and we need to have, because we know that there are some signs that are up there that should not be. We are a tribunal, and so we really shouldn't be, and we want to be able to listen and not prosecute. My son is an Eagle Scout, and his Eagle project was welcome to Flint Hill signs. And when those signs went up, people came to us, or there was a store next door to us at the time. They were coming, it's the first time, you know, Flint Hill's been here since like 1750, but it's the first time we've seen a welcome to Flint Hill sign. And we went through all the permitting processes, because that's what you do, what the Boy Scouts have to do, is to learn how that little government stuff works. And so I know that it is a bit of a process. So, it is nice to see welcome to Flint Hill signs. So welcome to Sperryville signs. So I too am a lot conflicted, because when you read the black and white words, it says signs going to be 75 square feet, da da da. So we are really in something between a rock and a hard place right now. And if there was some way that we could come up with a solution, cover it up until we can get the Board of Supervisors on the same page or something like, I don't know, but anyway, I just wanted to let you know that I've really taken much of your comments, and I guess we've been working this 3 months now, right? April, May, June, something like that. So we really do pay quite close attention to our community.
The other thing I would like to just throw out is, and the lady in the back who brought this up about the legal points or whatever, but to me it doesn't matter. I don't care if he called it a sign or if he confessed to it being a sign in April or whatever. That's not relevant in my view. Maybe you did, maybe you didn't. It doesn't matter. That has nothing to do with it. What is interesting to me is, can we make the determination that it is not a sign? And it may well be a mural as well, but that is the question that I think I'm struggling with. And because even these exceptions, while that is brought up as a possibility, I don't think any of them fit this sign or mural or whatever it is. So, I think some of the items that have been brought up are not really relevant, just the same way as how attractive it is and how much business it has brought. I mean, there are other ways to have a welcome to Sperryville sign that could convey the same message, be visible, and do the same thing, that could be done in compliance with the ordinance. Or otherwise, as Jennifer said, the supervisors could look at the ordinance, and with a very small change, this all is not a problem. And they have chosen either not to do that, or maybe they are. So, I think that remedy is still out there. And that's very much more of a political organization or group than what we are, because we're more of a interpreting or making sure things comply with the ordinance, as opposed to making new law or, exceptions and so forth. That's just my opinion.
Well, I want to echo what Mr. Makala said. You know, he's the newest member on the board, and also what Jennifer Matthews said, who I think was the member with the most seniority. And, you know, as I look around the room, the board members accepted, I see 5 people in this room: Robin, Sherry, Martin, and Sharon, and that's it, who were here in and Diane Bruce, who were here in 1984, 5, when this zoning ordinance was adopted. And just to give you all some historical perspective on why what's in there or how what is in there got to be in there, I have to tell you that at that time I was zoning administrator in Michelle's position, and thank you, Diane, and participated with the Planning Commission over the course of about 2 years to rewrite what is mostly still in place in the zoning ordinance, including the sign provision. The previous ordinance, I don't think it had anything about signs, and if it did, it was 1 or 2 paragraphs. It wasn't much. And this was brought in to us by Dick McNear, because that's what Fauquier, we modeled our ordinance on what Fauquier did, which in turn modeled their ordinance on what Fairfax did. And this Article 12 probably got more discussion and debate amongst the Planning Commission members than any other provisions of the ordinance. And some people thought it was too restrictive, and Dr. Krebser for sure thought it wasn't restrictive enough. Phil Irwin, he doesn't come to our meetings, but Phil Irwin could attest that there was a big move in the country, and especially in Rappahannock at that time, and your father was part of it too, Chris, to get rid of all these commercial signs and billboards that were all over the county. They were viewed at that time as a real eyesore. Some of them were in kind of a state of disrepair. There were a lot of people here, including your parents for sure, that were proponents of Lady Bird Johnson's beautification program to get rid of all the billboards on the highways. And so what's in the zoning ordinance reflects all of that. The overwhelming sentiment in the county at that time was to limit signage, especially in the highways and in the villages. And from my own perspective, which is relevant tonight, I was very concerned of how are you going to enforce it, because there was a lot of, and it's still in there, about non-conforming or pre-existing signs. How are you going to regulate them? Or how, we didn't have a list, we didn't have any kind of register of them, and there was supposed to be a register made. I at that time, for other reasons, departed the zoning office, and it was never done, just as I predicted. And so some of these signs that some of you are complaining about, that our billboards are not conforming or don't conform to the present code, even I'm not sure when they went up and when they were put there, because the ordinance wasn't followed after it was enacted. And to me, that's sort of a different issue. The issue that's before the board is a very discreet one. And I hope, and I just want to echo what everybody else said, I hope that you folks, most of you out there, support this. And whether you support it or like it or don't like it, we live in a society that goes by the rule of law. This board doesn't have the authority to change the law.
No, you can interpret it.
That's right.
We can interpret it, yeah. Okay, that's all we can do. But we have to interpret it in accordance with other laws and case decisions and so forth. And the interpretation part comes where the law is ambiguous. And so before you start interpreting, you have to make a finding that it's ambiguous. Otherwise, you go by the letter of the law. And I think that if we If you're not, just like was said, if you're not happy with the outcome, if you're not happy with what the law says, the remedy is to go to the Board of Supervisors and ask them to change it. But when you do that, or if you do that, keep in mind that you can't regulate content. If you increase the size limitations for signs from 75 feet to 100 feet, or 250 feet, or 300 feet in the village commercial, and you allow people to have wall signs of that size, just like in the Wagmore dogs, or more, what is it, Wagmore, yeah, dog case in Arlington, as they said, the county or the Arlington County has the right to regulate this because that's one of the purposes of zoning. And if they would allow that mural to stay, then everybody in the whole district and all over the county could put up other signs of the same size, and you can't, well, you would have what the court called a cacophony of signs all over the county. So that's one of the things you have to take into consideration, but that's not our consideration. That's what the Board of Supervisors, when they perform their legislative function. But they have given us a code, and the code says what it says. And it defines a sign as, I'm not going to read it again because it's already been read twice. It says what it says. And this, it doesn't matter if you call it a mural or a work of art or whatever, it meets the definition of a sign. It's got letters and it's got words, right? It says, "Welcome to Sperryville." It informs people of something, that they're in Sperryville, and it's visible from adjoining properties or the highway. And those are the three tests for a sign, and it meets all three of them. And in my mind, there isn't any ambiguity about it, there isn't any question about it. Whether I love it or I don't love it, whether I love Mr. Chapman or I don't love him, is irrelevant. It has nothing to do with my view of the issue. The issue is, does it meet the definition? And the answer is yes. So it exceeds the limitation, which is 75 feet. If Mr. Chapman wants to do the same exact thing and make it smaller, he can do that. If somebody else wants to do it, they could do it, or they could put "welcome to" and put "Sperryville" on this. I don't know. I'm just saying those are the rules that everybody's got to live with, and until they're changed, that's the way it is. And we do not have the authority to change it. We got an opinion letter from the county attorney back in June, and he said this. He also read us the definition, or recited the definition, and basically said there's no question that it's a sign. And furthermore said we don't have legal authority in the BZA to grant a variance from the size limitation. And he said right at the end of this memo, which is on board docs, and I don't know if you want to put it up there, it said right at the end, the reason we can't give a variance is because one of the tests for a variance is that can the issue be resolved through an amendment to the ordinance? And the answer is yes, it could be. And he suggested one. And why the Board of Supervisors hasn't addressed it, I don't know. They don't really pay much mind to what I tell them. Or suggest to them. So that's for y'all to suggest to them. If that's what you and a majority of people think is the appropriate outcome, change the limitations. But again, I just want to say, keep in mind, once you change it, you can't regulate the content. And the fact that everybody loves it, somebody could put up a sign that has something on it that you hate. And like I think Justice Brandeis said, the First Amendment doesn't protect the speech we love, it protects the speech we hate. So it's a free speech issue, and the cases that Mr. Brown and I have been kicking back and forth. Wow, nice.
Actually,
the cases that we've been discussing go to that issue, so.
I'm prepared to make a motion. Okay, would you, I'll entertain a motion.
Well, I was gonna finish with the motion, but you go ahead and make your motion.
I would like the motion that
Make a motion.
we accept the determination of the zoning administrator and require that the sign be removed within the next 12 months.
I don't think we have the authority to do that, because.
Do we not? I mean,
the authority is the zoning, and once you make a determination, the zoning administrator is required by law to do what he's got to do. And you can't, I don't think you can put that on there.
Or it could be covered until further.
my point being that this gives us
In other words, you want
time
to suspend it? You can't suspend, you want to suspend the operation of the decision?
No, I'm saying that the zoning administrator did her job. That's what we pay her to do. She looked at the ordinance, and that's the way the ordinance reads. I think there's a general agreement amongst the majority of people in the county that we've got a problem with the sign ordinance. And we've got to deal with that. And what I am proposing is that we support our zoning administrator, and that gives us 12 months for the community, the citizens, to go to the Board of Supervisors and whatever, and get this sign ordinance changed so this type of thing becomes acceptable, because it's acceptable in numerous areas. You just have to drive over the mountain to Luray. It's there. It's no problem.
I don't know about it.
But it would take a second, but that's my motion. I don't see any other way we can go. She did her job.
Is there a second to the motion?
Well, second, it was a modification, and that is to remove the 12-month thing, because we.
Make a new motion. I mean, let's say
I think
there's.
that one dies.
Did that one not get a second?
Then I'm not.
Go ahead, then make a motion.
My motion is as the code says, that the determination of the zoning administrator is presumed to be correct, and it's the burden on the appellant to overcome that, and I haven't seen any evidence or any other interpretation that gets me to anywhere except that she did make the correct decision. So I would, and that's all the code says we can do. We can affirm it, we can reverse it.
So why don't you?
So I make a motion that we affirm the zoning administrator's decision. And what happens in terms of her taking other action is not something that's within the purview of the board.
Is there a second to that motion?
I will second it.
Okay. Is there any further discussion? All in favor?
Aye.
Aye.
Abstain. Based on the fact that this county
Okay,
has...
okay. Wait, this is fine, we're going to do a roll call.
Okay.
Chris?
Mr. Byrd?
Mr. Byrd?
Abstain.
Mr. Macklin? Mr. Conant?
Aye.
Mr. Sharp? Aye. Ms. Matthews?
Aye.
Dr.
Regretfully.
Okay.
Can I explain my abstention?
Sure, go ahead.
As Mr. Conant has done in the past.
Sure.
We have a problem with our sign ordinance in Rappahannock County. It's not been enforced since it's been put into effect. We have signs throughout the county that violate the ordinance, and so therefore I cannot cherry pick a sign and say this one is in violation when there are numerous violations throughout.
Okay, well, why don't you report them to the zoning administrator? Tell her to take it.
Okay.
I would ask the community to do that.
I want a motion, I ask for a motion to adjourn. I move to adjourn. Is there a second?
Second.
All in favor? Thank you, everybody.